Mr. Murali.
Mr. Deputy Speaker, sir, I rise in support of the bill. As mentioned by the honourable members of Parliament who spoke before me, in particular Engineer Dr. Lee Bee Wah, Singapore is an international travel hub. About 7,200 flights land or depart from Changi Airport each week. As at November last year, approximately 60 million passengers passed through Changi Airport in 2018. These travellers come from all over the world. Greater travel connectivity and movement of people comes with the attendant risk of spread of diseases, something that the Honourable Senior Minister of State, Dr. Lam, highlighted. These proposed amendments to the Infectious Diseases Act allow the government to enhance infectious disease surveillance and equip us to better prevent the spread of infectious disease, both within Singapore and from outside Singapore into Singapore. I would like to commend the Ministry for its efforts to consult stakeholders over a 6-week period before finalizing the bill which is before Parliament today. I seek clarification on 2 areas. Section 21 of the Act is proposed to be amended to allow the government to take a more calibrated approach to address the risk of the spread of infectious diseases by persons who are carrying infectious diseases. Instead of a blanket ban against carrying on any occupation, trade or business, which is presently the case, the amendments allow the authorities to make an assessment of the extent of the risk in the circumstances and make appropriate orders as necessary to prevent the transmission of infectious diseases, which may not need to be a complete cessation of trade or business. And the learned Senior Minister of State mentioned about food handlers as an example. This calibrated approach will be less disruptive to businesses and traders. I welcome it. The amendments, however, do not provide direct assistance to a person who has been ordered by a director to cease business to prevent the spread of infectious diseases. To illustrate, if a person who is a carrier of an infectious disease, such as dengue or measles, is afflicted and he is asked to be quarantined, for certain occupations, such as self-employed persons like taxi drivers, they may still have to honour their contractual arrangements with their counterparties. For example, the taxi companies, for the period they should be quarantined so that they will not infect their passengers. It is commonly provided in agreements between taxi companies and their drivers that they have to pay rent for hire of the taxi if they have MC for longer than a defined period, for example, 7 days. This creates a potential conundrum for the self-employed persons who may be caught between a rock and a hard place. If they abide by the director's orders, they may be exposed to liability vis-à-vis the counterparties. This is not a theoretical musing. I met a gentleman at a funeral wake of his relative. He related to me that he was given 14 days MC for his infectious disease. However, he was required to pay rent after an initial 7-day period. He was unable to secure cover because of the suddenness of the situation. He had no choice but to pay rent even though he was quarantined at home at his doctor's orders. In contrast, Section 20 of the UK Public Health Control of Diseases Act 1984 provides for local authorities to, by notice in writing, request any person to discontinue work, and in such instances, the local authorities may have to compensate the person if he has suffered any loss in complying with such a request. Section 20 of the UK Act has since been repealed and replaced with Regulation 8 of the UK Health Protection Local Authority Powers Regulation 2010, which continues to require the local authorities to offer compensation. Apart from a written request in writing to stop work, Section 45H of the UK Public Health Control of Diseases Act also allows for the local authorities to apply to a Justice of Peace for an order to impose restrictions or requirements to protect human health. The order may involve the payment of compensation or expenses in connection with the taking of measures pursuant to the order. The point is that the UK provisions contemplate the authorities giving compensation where a worker's work or trade has been affected by a measure taken in protection of public health, such as a stop work order. In Singapore, we don't have that, which means that the risks may lie entirely with the trader or worker concerned. Even if we do not go so far as to compensate people in respect of stop work directions given, perhaps we can consider at least having a statutory basis for people to be relieved or held harmless from liability for their contractual business or trade obligations for the period they are directed by the director to do an act which renders them unable to perform their work obligations. Next, Section 6 of the Act is amended to, or is proposed to be amended to require certain persons who are aware or suspect that another person is suffering from or is a carrier of a prescribed infectious disease to notify the Director of Medical Services of those facts. The section previously made reference to infectious disease, which is specified in the first schedule of the Act, instead of prescribed infectious disease. The amendments also provide that what amounts to prescribed infectious disease will be set out in the regulations. Given that the Act already spells out what amounts to infectious disease in the first schedule, and also spells out what is dangerous infectious disease in the second schedule, may I please ask what will be covered under the new defined term of prescribed infectious disease? How will the list of prescribed infectious disease be drawn up? Will there be any interplay between infectious diseases set out in the first schedule and the list of prescribed infectious diseases? Or is it contemplated that the application of the prescribed infectious disease list was only in respect of Section 6 of the Act, since no other sections of the Act refers to prescribed infectious diseases? So before I sit down, I would like to make reference to a point made by the learned Senior Minister of State. He mentioned that MOH received plaudits from the World Health Organization for its ability to successfully detect and prevent the spread of infectious disease. This is a hard-earned reputation, and frankly, whatever we pass today in-house, it is the capability of MOH and its professionals that would make a decisive difference in the fight against the spread of infectious disease. And in that regard, we should never forget the heroes such as Nurse Hamida Ismail and Dr. Alex Chow, who lost their lives in helping Singaporeans during the SARS incident. And they always would deserve our eternal debt of gratitude. Thank you.